SJC-10075, Commonwealth versus Vargas.
Thank you. Mr. Thompson, good morning.
Good morning, Chief Justice Gantz. May it please the court, my name is John Thompson. I represent Pablo Vargas in his appeal of his conviction for a first-degree murder by extreme atrocity or cruelty and the denial of his motion for new trial. There are a number of issues that I'd like to address today. There were a number of things that went fatally wrong with this trial. The first I'd like to address is that the fact that the statement that was made by Mr. Vargas a couple of hours after the fatal fight should have been suppressed. And it should have been suppressed on two grounds. One, his telephone rights were intentionally violated. And
where does that come from? I was looking through this and trying to figure out how I can be sure that that's what happened. Where does that come from? Why do you say that?
the evidence is in the motion to suppress hearing transcript
Okay.
that occurred on December 19th, 2005 with Judge Ford. Excuse me. The testimony was, and the evidence was, that Mr. Vargas was taken into custody at the scene of the crime at about 11:45 and was taken, according to Detective Carter, to the police station, arrived there no later than 12:20 in the morning. He was handcuffed to a chair in the Detective Bureau main office for about an hour and 20 minutes until about 1:40, when he was taken to an interrogation room by two detectives who then set up a recording device. This was shortly after the D. Giambattista ruling, and began to interrogate him at about 1:45 a.m., which is a time that's noted on exhibit, excuse me, the Miranda warning, telephone warning, rights form at appendix page 55.
So is the intentional, what is the intentional violation here?
The intentional violation is
Time?
the time. The statute requires that the person in custody be notified within an hour of, and given the opportunity to use the telephone.
So this was an hour and
This was an hour and 20 minutes,
20 minutes?
an hour and 20 at least. It may have been closer to 2 hours, but at a minimum, it was an hour and 20 minutes.
Okay. Do you dispute, I think, what Ms. McMahon would say, granted, it wasn't within the hour, but once the interrogation started, are you saying that I'm not clear about this. The interchange between the sergeant and the defendant about the telephone, and your client says, yes, I want to use it. Are you disputing what the response to that is from the police? I mean, are you saying that's another violation, that they should have given him the phone right then?
Yes. Yes. That's the purpose of the telephone right, is to allow him to contact somebody.
Wasn't his statement, or wasn't the evidence that the officer, it was Sergeant, right?
Sergeant Carter.
Said you can use it at any time, or words to that effect?
No.
What did he say?
He said, and there's a little ambiguity in the record on that, but first of all, he never used the phone. That's the fundamental fact. He asked to use the phone. He said he wanted to use the phone.
They said, do you want to use the phone? And he said, yes, I do.
That's right.
And they checked that off.
He had him, Sergeant Carter had the defendant check off that he had actually used the phone. If you look at the form in the appendix, page 55, the used the phone is checked as if he had used the phone. That did not happen, as was established in the suppression hearing. What was unclear was whether or not, I think Judge Ford made a finding that Vargas said that he wanted to use the phone at some time, but not right then. There's no evidence to that effect whatsoever. As a matter of fact, what Officer Schink said was that Officer Carter said that we'll let you make the telephone call later. We'll let you make the phone call later. And Sergeant Carter admitted that he said something like that, and they never actually let him use the phone. But I think it's also important to notice that they didn't give him the notification until after he had waived his Miranda right. They use a form here that has the Miranda warning at the top and the right to use the phone at the bottom. And of course, the Miranda warning, the police purpose, is to obtain a waiver. So the way things started here was that this man was held for about an hour and a half in the Detective Bureau office. Officers approached him and talked to him. Officer Schink said that he talked to him about his willingness to talk to the police. So before they took him into the interrogation room and gave him his Miranda warnings, they got him to agree that he wanted to talk to the police. Then they gave him his Miranda warnings, and during the Miranda warning, he made an ambiguous invocation of his right to counsel. They blew by that, and then once he had waived his Miranda rights, they told him about his right to use the phone. And when he said he wanted to use the phone, they told him, not now, you can use it later. And he never actually got to use the phone. And they went right into the interrogation then at that point, after he had made 2 efforts to exercise his rights, and neither one of them succeeded. Now that is, I think, that's an intentional, under the Jones case, which is the 1972 ruling by this court that I'm relying on. The Jones case says that police should be held strictly to account for their conduct in relation to the defendant while he is being held incommunicado. This man was being held incommunicado. He had just been in a fight with a man in which he killed the man with a knife. He was taken directly to the police station. He sat in the police station for an hour and a half, and the only contact he had was with police officers who solicited him to talk to them, and then took him through his waivers and withheld his rights from him. They held him incommunicado, and then the interrogation was conducted immediately after that. While he was being held, the police were talking to other witnesses and obtaining information that they used in interrogating him and in attacking his self-defense claim, which was that the man who attacked him had a gun in his hand. So this was not only intentional, it was purposeful. That is, this was the officers held him incommunicado, didn't tell him about his right to use the phone, which he wanted to use, because he had a lawyer, the lawyer who represented him at trial. He had an attorney-client relationship with Mr. Glenn. It wasn't a criminal case, in a civil case, and he was trying to reach Mr. Glenn.
Do you have a different outcome if it's intentional rather than just a negligent violation of the right?
Yes. The law, in Jones and thereafter, this court has said that the violation has to be intentional. That is, though, just knowing. That is, the police know about this right. They have to intentionally not advise him.
So other than the timing, what is there in this case to suggest that it was intentional?
The timing is one part of it. The use of this combined form is another. That is, this shows that the right to use the phone typically is not related to the suspect until the Miranda process starts. So, of course, the Miranda process starts when the police initiate the interrogation. So the timing of the statute is designed to give the suspect the opportunity to contact someone. It says so in the statute, to contact family, attorney, anyone who will break the incommunicado. This is the classic Miranda situation. This is Massachusetts. I think Massachusetts' contribution to meeting the goal of Miranda, which is to break the incommunicado status of the suspect and give the suspect an opportunity to talk to someone outside the police circle, either contact an attorney or have someone else contact an attorney for him. And that's particularly important when it's the middle of the night, as it was here. It was after midnight. So,
If I can turn your attention to a
Yes.
different subject, because you're half done. In this case, there was a request for an adjutant instruction.
yes.
Was there instructions as to voluntary manslaughter?
There was an instruction as to voluntary
As
manslaughter.
to all three theories, a sudden combat, reasonable provocation,
and
excessive use of force, and self-defense?
excessive use of force, yes.
So all those were given.
They were given.
uh,
They were defective.
Defective as to the excessive use of force and self-defense, you contend,
Yes.
but
yes.
not as to the others.
Well, there were related problems with the instructions. The adjutant instruction was not given. There was clearly an adjutant situation. The prosecution argued that the defendant ambushed Mr. King.
But was there an adjutant situation or a Chambers?
There was a Chambers situation.
But this was, of course, before Chambers was issued, I think.
Yes, but defense counsel raised the issue of the question of the evidence was going to be disputed over who introduced deadly force in the situation. So that was raised in the motion in limine hearing on June 8th, on May 8th.
Was there, remind me, was there evidence concerning the victim's prior violence?
There was. There was evidence presented because Ms. Rodriguez, Mr. King's estranged wife, had told Mr. Vargas of basically some of the story of her his abusive dealing with her. So he knew that, Mr. Vargas knew that Mr. King had.
That all came out.
That was presented to the jury with a limiting instruction that it was only relevant to the defendant's state of mind and couldn't be, in other words, couldn't be considered for adjutant purposes.
So that was what was permissible before adjutant, which is that if you
That's
know of that individuals, you may consider it in terms of your own state of mind as to your need for self-defense.
That's right.
But it did not come in terms of getting a sense as to how this whole thing played out.
That's right. The evidence that was presented on that point was specifically not adjutant evidence. Okay? There was also, the judge refused to instruct on defense of another, which was clearly in play. That is, the scenario here was that Mr. King broke into the apartment or sneaked into the apartment and immediately attacked Ms. Rodriguez in the dark in the first room, and her screaming, her cries brought Mr. Vargas into that room, and then Mr. King attacked him. And in that situation, there should have been an instruction on defense of another.
But didn't the actual fighting happen back in the bedroom?
No, the actual fighting started right there. According to Ms. Rodriguez, Mr. King immediately sort of bull rushed Mr. Vargas, knocked him back into the other room where the guns were and where the knife was. There were 2 knives and 2 or 3 guns in that room.
So at that point, doesn't it become self-defense? I mean, I guess where,
It does become self-defense, but because of the way this case was argued, the prosecutor argued that Mr. Vargas wasn't entitled to self-defense because he was there. That is, he should have left that place, which was Mr. King's former apartment, and he knew that that was going to be a volatile situation if Mr. King showed up.
But he got a self-defense instruction.
He got a self-defense instruction, but the instruction didn't focus on that point. That is, the instruction is vague on at what point does the duty to avoid combat arise? It arises when you're attacked. But the instruction didn't say that. And the prosecutor argued that Mr. Vargas didn't have the right of self-defense because he was there, because he should not have been there. He knew that there was at least a possibility that Mr. King was coming, and so he should have left. Because he didn't leave, he didn't do everything in his power to avoid combat.
So that's what the prosecutor argued to the jury.
That was what the prosecutor
That
argued
he had
to the
no
jury.
right to self-defense because he should not have been there and therefore did not take steps to avoid the situation.
He didn't. That's right. He didn't do everything in his power to avoid combat. So,
Before you leave this issue, I gather that you mentioned that Yaniro had spoken of the victim putting the defendant into a chokehold before the killing when she spoke to the police.
yes.
But was there any evidence at trial that the victim had put the defendant in a chokehold?
No. What the evidence at trial was, Ms. Rodriguez said that she saw Mr. King on top of Mr. Vargas, pinning him down and hitting him. She told the police that he was holding him down with a forearm across Mr. Vargas's throat. Okay? The reason that was important is that there were very few visible injuries to Mr. Vargas, and the prosecutor argued that he wasn't actually in fear of his life because he wasn't actually injured, and Ms. Rodriguez wasn't actually injured. The fact of the matter was, of course, it's not just visible injuries that measure that, but it's a telling argument. There wasn't a lot of evidence that Mr. Vargas actually feared for his life, except his own word. But there was evidence that forearm hold is an unarmed combat hold that, according to Mr. King's companion, Mr. Hall, he'd been trained in unarmed combat as part of his work to get ready to go to Iraq. Dr. Zeisel, the expert that I suggested that I proffered in the motion for new trial, is a combat psychologist who worked in Afghanistan and Iraq and works with U.S. police forces. He would testify, he will testify if given the opportunity, that kind of hold, first of all, creates a sensation of being in danger of losing your life. It can cause temporary unconsciousness, which also causes trouble with perception and memory. In other words, it would give a fuller explanation of what was happening to Mr. Vargas at the time that he got hold of this knife and killed Mr. King.
Help me about the relative sizes of the victim versus the defendant.
I'm relying on the Barnacle case for that, which I think stands for the proposition that some people are armed by nature vis-a-vis others. King was about 6 feet tall and 200 pounds, and he was a trained soldier who was trained in unarmed combat. Vargas was about 5'6", he weighed 150 pounds or less, and when this started, he was unarmed. So under Barnacle, at that point, when he's attacked by that much larger, more skilled fighter, he at that point has a legitimate fear of that his life and limb are in danger and is entitled to use deadly force in self-defense without proving that the other man had the gun that Mr. Vargas said that he had in his statement to the police.
Now, are you claiming that the jury instructions did not permit the jury to make that conclusion?
The jury instructions...
I know that if you were to argue this case again, you would say, after all, Mr. King was in the military, he was trained to kill, that's what you learn, and given the relative size and the knowledge of his training, that his own hands could be themselves a deadly weapon, and that therefore he acted in self-defense. Was there anything that the judge said which would have deprived the defendant of that defense in this case?
No. What I'm saying is that the evidence was available, it wasn't presented, that would have bolstered the defense significantly on that point. At that point, I'm not complaining about the instructions. The complaint about the instructions is that there is a path that the instructions sketch out that allow the jury to convict this man on first-degree murder by extreme atrocity or cruelty on findings that he acted with excessive force in self-defense.
And there was no excessive force instruction?
There was an excessive force instruction, Justice Botsford, that was defective. That is, that said, if the Commonwealth, well, let me begin. The instructions begin 3 times. The judge tells the jury that they can infer malice alone from the intentional use of a deadly weapon, without in regard to whether or not there are mitigating circumstances or excessive force. So then the judge told the jury, if the Commonwealth cannot prove beyond a reasonable doubt that the defendant acted with malice, then they have to consider the mitigating circumstances. But they could already have found malice from the intentional use of the deadly weapon.
Sorry, the judge told the jury that first they determine whether there's malice, and then they get to the mitigating circumstances?
I'll read the instruction. If the Commonwealth cannot prove beyond a reasonable doubt that the defendant acted with malice, in order to obtain a conviction of murder, the Commonwealth must prove beyond a reasonable doubt the absence of these mitigating circumstances. The obverse proposition is that if they have proved malice, there's no need to consider mitigating circumstances. And if you do consider mitigating circumstances, you can infer them without regard to the burden of proof. It doesn't have to be beyond a reasonable doubt. Then if the jurors got to the point of considering and finding excessive force in self-defense, the judge said you'd be justified then in finding voluntary manslaughter. In other words, it's an option. The next instruction is, but of course, you have a duty to convict him of the most serious offense that's been proved. And since excessive force meets 4 of the Canine standards, or the Canine factors for extreme atrocity or cruelty, there's a direct path. The use of the knife establishes malice. The excessive force establishes extreme atrocity or cruelty. And the mitigating circumstances don't have to be considered, and the jury could find him guilty through that reasoning path that's laid out in the instructions of extreme atrocity or cruelty, even if they thought he was acting in self-defense but used excessive force.
All right, thank you.
That would be a miscarriage of justice.
Thank you.
May it please the court, Catherine McMahon, Assistant District Attorney for the Hampden District for the Commonwealth. In the defendant, pardon?
Welcome back.
Thank you. In the defendant's appendix, beginning at page 17, there's a transcript of the defendant's custodial interview. The very neat printing is that of Ms. Montori correcting some omissions in that transcript. In the appendix to the Commonwealth's brief, we have the actual recording of the defendant's interview. It was the recording, not the transcript, that was submitted to the jury. The motion judge on the defendant's motion to suppress, the motion was focused on whether he had unambiguously asserted his right to counsel, but there was testimony concerning his right to use a telephone call, and you can see that at the beginning on page 21 of the transcript of the interview. So there's evidence there, even though that the use of a phone call was not a premise of the defendant's motion to suppress.
Okay, if I could turn you to the question, I guess the broader question, which I might as well ask you now. How can this not be a case of voluntary manslaughter? I mean, he's coming in, the person barges in, you concede that the victim attacked the defendant and was pummeling him, and that the killing occurs during the course of the melee, which was initiated by the victim. I mean, how can this not be in sudden combat or reasonable provocation or excessive use of force? How can this be a first degree as opposed to voluntary manslaughter?
There was conflicting evidence as to whether the victim was armed when he barged in. There was no dispute that the victim was the initial aggressor, that he barged into his apartment, he attacked his wife, and then he attacked the defendant physically. The defendant said he saw the victim with a gun in his hand, but the victim physically attacked him without a weapon. It was the defendant who introduced deadly force when he picked up a knife in the bedroom and stabbed the victim 8 times and slashed him twice. The victim had 4 fatal stab wounds as well as 4 others. The defendant had a couple of small cuts by the side of one eye. The victim's wife didn't have any injuries. So you have 2 people's version of events, that the victim attacked with his fists and his hands. You have both of them not being injured at all, and you have the victim being fatally injured, 4 fatal wounds. A military person much larger than the victim, trained in like hand-to-hand combat, and he's the only one.
Military person, the victim was the military person.
Exactly.
And the victim was the one who was much larger than the defendant.
Yes, that's what I thought I said. Did I say it backwards?
Verse.
No,
but,
she said that. She said that.
Did? Okay.
Okay.
Your point was, however,
So, taking the evidence, well, we're not taking the evidence in the light most favorable to the defendant. That's for terms of a jury instruction. But the jury was warranted in finding that even though the victim, who's much larger, physically attacked the defendant, once they were in the bedroom, which was not disturbed, there were pools of blood, but there was nothing knocked over or disturbed, that the defendant, as the prosecutor argued, ambushed him by stabbing him several times. So it was a
the ambush-
non-deadly combat moving into deadly.
How did it get into an ambush?
That the defendant had the knife already there in the room. His story was that he brought the knife to his girlfriend's apartment because he wanted to sell it. He hadn't brought it before, and it was out. It was in a sheath, but it was out and available to him in the bedroom. There was also evidence that he had said at some other point in time that if the victim showed up, he would stab him. That was from the victim's wife. So even though the jury did not find deliberate premeditation, there was evidence for them to find that the defendant had a weapon ready in case he needed to use it. And it was a jury question whether the larger victim's attack on the defendant justified the defendant in using deadly force or not. And the jury found that it didn't.
But given your description, doesn't that demonstrate the importance of the adjutant evidence with regard to the history of violence that the victim had, and the fact that this may bear on whether this was truly an ambush or whether this was self-defense or whether it was whether this was reasonable provocation or sudden combat?
This was post-adjutant because there was a request for an adjutant instruction, but it was pre-Carter. So in terms of discussion of,
Okay, wasn't it, I mean,
It-
I thought your point is there was no dispute that the victim was
the
the
victim
first
started
aggressor.
it.
So if
there-
that's what adjutant was there for.
Yes, it's who was the initial aggressor.
Okay, but then you have Chambers, which speaks about that it's more than just who struck the first blow.
It's who first introduced deadly force, and the only one who used deadly force was the defendant in terms of using a dangerous weapon.
But that's another. I mean, could the jury not infer that this particular victim in the military, trained, learning how to kill, which is what you do, could have used deadly force without the use of a dangerous weapon?
Deadly force is usually use of a deadly weapon. He had a gun, he didn't use the gun.
I understand, but
Right,
somebody can
but so-
strangle somebody to death,
And
somebody
the
can pummel
jury
somebody to
had
death.
before them the usual instructions about you can take into consideration the relative size of the combatants, into whether the defendant reasonably and actually believed that he was in imminent danger of death or serious bodily injury, where therefore he could use deadly force. So that was there. In terms of who was the initial aggressor, there was no dispute. That's why the judge didn't give an adjutant instruction. The jury did hear about the victim's violence towards his wife, but it was not given to them for the purpose of discerning who was the initial aggressor. I concede that. It was as to the defendant's state of mind when he saw the victim, knowing his history. Unfortunately for the defendant, in his statement to the police, he said he didn't know who the person was who barged into the apartment. So the victim's history didn't play any part in it. He did not know who his attacker was. It was just a man who came in.
I take it this case was tried in 2006, so right
Yes.
after Adjutant and long before Chambers, 7
Yes.
years before Chambers.
And that's the posture in which the parties were arguing it, and the Commonwealth conceded that the victim was the initial aggressor.
Okay, so does the Commonwealth concede that that the defendant was acting in self-defense when the victim came in and attacked him?
But not that he wasn't entitled to use deadly force.
Well, I understand that, but
right.
isn't that the very essence of excessive use of force in
No,
self-defense?
if you use deadly force when you're entitled to use non-deadly force, it's not self-defense at all.
Well, I understand that, but
Yes.
but then doesn't it
But
become
if
the
you
manslaughter of excessive use of force in self-defense?
If deadly force and non-deadly force are two separate things. If you use deadly force in a situation where you're entitled to use non-deadly force, it isn't self-defense, and it isn't excessive force in self-defense. It's not justified.
Well, I know it's not justified, but isn't that the very essence of,
No,
of mitigation? Really?
I think it's,
You're saying that when somebody is justified to use non-deadly force in self-defense, but uses deadly force,
it's not.
that's not voluntary manslaughter?
No, it is not. And that's based on, I'm not the author of the Commonwealth's brief, so I think it's Commonwealth versus Toon, which is a Mass Appeals Court case, and Commonwealth versus Watkins or Wilson, and I apologize, but this court in Watkins or Wilson clearly differentiated between when you can use deadly force and non-deadly force, and when you use deadly force in a non-deadly force situation, it's not excessive force in self-defense, it's unjustified, you don't get a self-defense
So
instruction.
when is it excessive use of force in self-defense? You seem to have read out the entire concept of excessive use of force in self-defense.
If you use deadly, and I'm repeating myself.
Deadly and you're
when
justified,
you're
it's
only entitled to
self-defense.
use non-deadly, it's not self-defense.
I know, I
It's not
get that.
excessive force in self-defense. It is absolutely not self-defense, and that's this court. They're two separate theories. You can use.
But my question is, I understand it's not justified to use deadly force when you're only entitled to use non-deadly force. But my question to you is, when is it excessive use in self-defense then?
If there was one stab to the victim and the victim immediately dropped to the ground and the defendant continued to stab him, that could be excessive force. It also could be heat of passion, that he was so terrified that he couldn't stop after the first blow. That could be excessive force in self-defense. It can be excessive if you do it before retreat, when there's an avenue of retreat. There's examples in the case law, but if he was only entitled to use his fists and his feet, and he used a knife, it's not excessive force in self-defense. It's murder. It's not manslaughter.
Let me turn to the issue of retreat. Is it your view that where, in a situation where somebody knows that somebody may come in what may be a hostile situation and does not leave, that the person then has lost their, I mean,
Absolutely not. That was an error in the prosecution's closing. But the trial judge, at the outset of his instructions, said, "You get the law from me." He said that, something to that effect in his general instructions. And his instructions on self-defense, he said the word imminent more than once. So it was clear that when you're faced with imminent threat of death or grievous bodily injury, you're entitled to act in self-defense. So the misstatement by the prosecutor was corrected by the clear instructions on the use of self-defense.
I guess the real core issue is whether or not it was clear that the duty to retreat is triggered only when the other individual uses force against, or uses force against you, or threatens force against you.
according to the evidence, and the defendant's theme was that the defendant was trapped, he was caught, he had no means. So the issue was clearly fleshed out in the arguments and in the evidence, but the defendant was in the back bedroom, and the only door was the door that the victim came through. There was no means of egress in there. And there was a focus on where there were pools of blood in the bedroom. That's where the stabbing occurred. And then the way the defense argued that the defendant had no place to flee, and the trial judge explained the duty to retreat and the imminence, which he said more than once. So despite the prosecutor's error, the jury was clearly instructed that they got an instruction on the right to use self-defense when you're imminently faced with that severe danger. So the error, which was not timely objected to, I think there was a request for a mistrial after the jury charge, did not create a substantial likelihood of a miscarriage of justice. Would you like me to turn to the right to use the telephone?
I'm sorry?
Sure.
Okay. The Commonwealth agrees that the defendant was in custody under arrest for assault and battery by means of a dangerous weapon at the police station. The police didn't have word yet that the victim had expired, but the defendant was definitely under arrest for the stabbing. And the defendant wasn't given his right to use the telephone until the custodial interview took place about an hour and 20 minutes after the defendant had arrived at the police station. So the statute says that a person who's detained should be advised of the right forthwith and allowed to use the phone within 1 hour. But to gain suppression of a statement that's given despite a violation of that timing, there has to be a demonstration that it was an intentional deprivation. That's not here. And in the
I'm sorry, it's not here because Judge Ford so found. Is there a finding as to that?
Finding simply that, I think the finding was simply that he advised.
yes,
That he
because
advised.
that really, there wasn't the issue that was, there was evidence on it and is part of the recording, but the thrust of the motion to suppress was the right to counsel.
And it wasn't raised in the motion or in the affidavit.
No, it was not. It was raised in the motion for new trial. But there's sufficient evidence there for you to make a determination that it wasn't intentional. The motion judge also heard testimony from Sergeant Carter and from Detective Schenck, who were the two people who were present with the defendant as well as the defendant. He discredited the defendant's testimony, credited the police officers. Those are credibility calls. Those are for Judge Ford and not for this court, but in terms of what's in the recording, that's documentary. You can take de novo. You're in as good a position as Judge Ford was in hearing what was in the recording and determining what the facts were, what was said. And the defendant didn't give his statement until after he had been advised of his right to use a telephone, and he didn't exercise his right to use a telephone at that point in time. So there was no unlawful fruit of the hour and 20-minute delay.
Well, was it clear, and I haven't listened to the transcript, but was it clear that when Sergeant said you have a right to use a telephone at any time, and he answered yes, right? You want to use a telephone, the answer was yes.
I think it's page 21 of the defendant's appendix, and it's where Sergeant Carter is like, it's halfway down the page to the end, and that's the exchange about the right to use a telephone call. And it's, as far as your rights to use a telephone, we'll make the phone call available to you. If you need to make a phone call, we'll let you do that. And then he goes into like filling out the form about being advised of the right, and he says, circle yes, phone use yes, we'll let you, or you can wait till you use the phone. And that has to do with writing the time in next to whether he got advised of the right. And they explain that he didn't put the time in because the defendant hadn't made the phone call yet, and apparently he never did make a phone call.
If I could turn you, Mr., I'm sorry.
No, you go ahead.
Mr. Thompson claims, and again, I've not gone back to look at the final jury instructions, that the jury instructions told the jury that essentially, if they were to find malice, that they do not reach the issue of mitigation as to voluntary manslaughter. Is that a fair reading of that?
I don't think it's a fair reading, and you look at the instructions as a whole, and there, right at the outset, the judge explained what's an excused or justified killing, and he specifically says one in self-defense. And then explains self-defense at more than one point in the instructions. And the instructions given in this case about excessive force and self-defense are unlike Santos, but are like Bowling, which is cited in the Commonwealth's brief, where this court found no problem with, I think it's a reading of the model instructions. The judge said the same thing here as the judge said in Bowling, and this court found no error. In the Santos case, the way it was worded was that if you found excessive force and self-defense, the Commonwealth proved murder. That was like the thrust of the argument, and here it was clear that the defendant, if the Commonwealth didn't prove that the defendant didn't act in self-defense, it had to be not guilty. If the Commonwealth proved excessive force in self-defense, voluntary manslaughter. There was no confusion that if you find excessive force in self-defense, the defendant's guilty of murder. It's just like the Bowling case.
Could I ask you a question back on the telephone? Mr. Thompson seems to me has an interesting and fair point about the form, which has Miranda first and then the telephone. Is that still the form in the Springfield Police
I
Department?
don't know if it's still the form. I hope it isn't, because there's also a gap of wording in the form about your right to consult with a lawyer. It left out the words an attorney.
Oh, I see, yeah.
So one would hope that it had been corrected.
It does seem to me that the order is reversed. I mean, it should be reversed.
Unless a defendant's going to say something incriminating when he's talking about his telephone call, it might be smart to give the person the right to remain silent before anything else, because as in the last case, you can't tell what a defendant's going to say. So giving the rights up front, the Miranda rights, which are Fifth Amendment.
Well, they really should be separated anyway, right? I mean, the phone should be something that happened before.
And I think on page 21, it looks as if they're talking about the right to use the phone and then immediately launch into questioning about who was Yanira King. I think there's a temporal gap. There's a few seconds in between, so it's not like here it is going right into the subject matter. But that will be clear on the recording, which you have.
If we could just turn very briefly to the interpreter. Critical witness in the case was Yanira.
Yes.
English is a second language, I gather, and requested an interpreter. Is that, I mean, given the importance of the precision of language, would it not be appropriate in the case of this type to make sure she had an interpreter?
She had the assistance of an interpreter for the cross, the redirect, and the recross. She didn't have the assistance of an interpreter because no one had requested it during the Commonwealth's direct. The judge did allow to have an interpreter once the defendant broached the question about whether she had difficulty comprehending English. The trial judge found that it was the phrasing of the questions as opposed to necessarily a deficiency in English speaking. Justice Kinder heard evidence on the issue in the motion for a new trial. Ms. Yanira King did not testify at the motion hearing on the motion for a new trial. Other people testified that her wedding was in English. She spoke to her children in English. She spoke to the witness in English. She used
English at work.
English at work. She had been born in the United States and gone to school up to the age of 9 in the United States, lived in Puerto Rico until late teens, where she went to school with Spanish language, but did have English language. And the trial judge, who has a discretion whether to allow a person to have an interpreter or not, didn't see, and he's the one who heard pages and pages of transcript, but he did allow her to have an interpreter. And with the assistance of an interpreter, I think she only utilized the interpreter twice once the interpreter was there. And the expert who testified at the motion to suppress believed that you had to be a high school proficient or high school graduate proficient in English in order to be competent to testify. The motion judge rejected that as being like too high a barrier, and he found that she was not deficient, even though he didn't hear from her. He read her testimony, and he heard from other people that she could converse in English. She didn't testify to anything technical. She testified to what she saw and what felt and experienced. She was able to give a narrative of what the events that transpired in the apartment, her background with the victim, and only use the interpreter twice once the interpreter was available to her. So there was no abuse of discretion. There's no substantial likelihood of a miscarriage of justice. There's ample evidence that this was first-degree murder by extreme atrocity or cruelty, and the Commonwealth would ask you to affirm the defendant's conviction.
All right, thank you.
Thank you.
Justice Gantz, if I may, there are a couple of things came up during the Commonwealth's argument that I'd like to address by letter.
May?